Morris, and I'm here on behalf of plaintiffs.
Colin Gatton on behalf of the defendants.
Mr. Gatton, you may proceed.
Mr. Honor. Summary judgment should be granted for the defendants because as the court narrowed the issue to whether or not they comply, the defendants complied with the 2017 meeting policy, and the record indicates that we have. So as point one, all meetings and events without exceptions will be preceded with not less than 24 hours prior notice issued by the BOCC staff and in the manner anticipated by the Open Public Meetings Act. Here, because we believe and have argued that these are all regular meetings that are in front of the court at issue, we have provided the 24 hours notice in accordance in the manner anticipated by the Open Public Meetings Act, because all of those agendas were posted 24 hours in advance on the county's website. Moreover, the county's website also indicates the location and the time and place at which all of these meetings would be held. Additionally, the agendas have to be a complete agenda when posted, meaning that they are covering all of the topics to be addressed by the Board of County Commissioners at that meeting. Those topics must provide an accurate impression of what's going to be discussed or acted upon at the Board of County Commissioners meeting. And further, we are not allowed, or the BOCC is unable to take action on any matters that are not on the agenda. Because these are regular meetings and the statute allows for, when they are regular meetings, to add additional matters at the meeting itself. This is a more restrictive requirement than what the OPMA requires. The record does indicate that in each of these meetings, the meeting minutes do indicate that a decision was made on Cortland, Green, or Hupy litigation for all of the meetings. Moreover, for each executive session that relates to those listings, they were properly entered into executive session where discussion was had and that no action was taken outside of the public view. The meeting minutes also show that there was no decisions made that were not indicated as topics to be addressed on each agenda. And insofar as that's the case, then there is total compliance with the 2017 meeting policy here.
Mr. Gatton, I have a question about the evidence here. It seems to indicate at least some instances where there was an indication of an executive session, and then after that executive session, the same topic was discussed in an open meeting, but that the agenda or the notice to the public with regard to that open meeting did not indicate that a decision was going to be made on that same topic addressed in executive session. Does my question make sense?
Yes, so I think what you're asking, and let me see if I do understand. So if you're saying that an agenda item or agenda topic was set for executive session, and then outside of executive session, final action was taken on that topic. That is correct. Actually, the topic was listed for the open meeting. However, under the executive session statute, it does not prohibit you in a regular special meeting from going into executive session and coming out of executive session. It is still an open public meeting, and you can take action, final action, on the same topic as long as it's done in open session. What executive session exceptions do is it prohibits the actions that you can take outside of the view of the public. It doesn't prohibit your ability to take action or final action on the same topic once you're done once you return back into open session.
Let me ask my question a little differently, because I think it's more subtle than that. So hypothetically, a government entity could have an executive session where it discusses things like litigation. And the next day or the next meeting or the next month, that government entity could make a final decision regarding that executive session. Or it could be done immediately after that executive session. So there's lots of options there. So for the public, wouldn't it be necessary for the public to know? In other words, if I was interested in that topic and it says executive session, if it's not listed on a public meeting agenda, then I would assume you must be making that final decision at some future at some future public meeting, and therefore I don't need to attend that because it's only going to be discussed in executive session. Does that make sense?
Yes, that makes sense, but I don't think that is when you look at the meeting policy as well as the OPMA, that's what's actually intended. Because in effect, when you put the topic on the agenda, you are giving notice that action, whatever that's going to be, is going to be taken on that topic. It does not mean that you're prohibiting making a decision, and it should not be the OPMA should not be construed to say that.
So, in your view, the OPMA allows an agency to make a decision on any topic that the public is given will be discussed in exec session.
Yes, I believe that is correct.
And what is your specific authority for that particular position?
Well, I think the specific authority are two pieces. One is that 4230-1101 requires...
Can you repeat that?
4230-110 subsection 1 requires or only allows an agency to go into executive session during a regular special meeting. You can also choose not to discuss that topic that is on the agenda in the executive session if you don't want to. You could, in fact, talk about those litigation matters without going into executive session at all. All the OPMA requires is that you list the reason for the executive session, and then also you also announce it to the public when they're there. And the purpose of actually putting an agenda topic on the agenda is to inform the public that action may be taken, whatever it's going to be. Secondly, I also think that this makes sense under the logic of the OPMA, because what we're really giving the public information on is the topic itself, and also informing them that something is going to happen on that topic. And the board or the governing body is not already going to know what they're going to be asked to do, if they're going to be asked to do anything, or they may decide not to do anything on the topic, despite council's recommendation or anybody else's, like director's recommendation, or whatever it could be. So I think that also plays into open session as well. I don't think you're required to delineate what action you're going to be taking for any topic on the agenda. For staffing, for example, you don't have to say staffing discussion, staffing deliberation, staffing action, and explain what that action is. More importantly, for executive sessions, and especially about ongoing or potential litigation, putting a topic on the agenda that explains specifically what your legal strategy might be seems to cut against what the attorney-client privilege exception allows under the OPMA, because it does allow a limited attorney-client privilege between agency and attorney, in that they can discuss the matters outside the open view, but then they would need to take final action in public as to what the litigation strategy would be.
So you just have a few minutes remaining. Do you want to reserve your time?
I would like to reserve. Thank you.
Thank you. Mr. Thomas.
Thank you, Your Honor. And so just to recap, we're here to talk about the 2017 meeting policy. Just to put it on the record, that meeting policy arises out of a case previously in front of this court and Your Honor with the same parties. I believe they're the same exact parties. And that case number for the record is 17-2-02371-34. And in that case, plaintiffs were alleging an Open Public Meetings Act violation. And before that case could go to any sort of hearing, defendants offered a CR 68 offer of judgment, which plaintiffs accepted. And when entering that judgment with the court, defendants attached a policy, a remedial policy, to bring them in compliance with the Open Public Meetings Act. And in fact, the judgment states that defendants shall comply with that policy for a period of 2 years. And there's not a dispute whether we're inside that period or not. So as this court stated in the issue on the June 14th hearing, is whether defendants complied with that policy. And the key points of this is whether defendants complied with making their notice accurate and complete. And that's what plaintiffs argue is lacking, is that this notice isn't accurate and complete. And plaintiffs break it down into 3 categories of meetings, one of which Your Honor already addressed, which is the notice for the executive sessions, but whereas defendants are taking action in open session without a separate notice for the action in open session, and then 2 specific meetings. So defendants argue during their oral argument that, we need to have flexibility because we can have this broad notice that talks about Mr. Cortland, Mr. Hoopy, and Mr. Green, and we should be able to talk about any one of them. But that misses the point of notice. The defendant's argument is that the notice is for themselves so that they can give broad notice and so that they can have the flexibility to talk about anything under that notice. But in fact, case law that's out of if we want to call this the response brief, plaintiff's response brief on page 9, the Washington State Supreme Court said in 1939, the essence of notice when in sufficient form and conduct is its objective consequence upon the person that receives it, not the subjective attitude of the person that gives it. And so defendants are flipping this, and so they're saying it's not for the person that receives it, it's not for the public, it's for defendant's benefit, and that's not true.
Mr. Thomas, there's nothing wrong, though, with the county wanting to be as broad as possible for its notice to the public and then making decisions to not discuss something in open or in exec session if it doesn't want to, or cutting short a certain topic in order to discuss another topic in greater detail. Isn't that correct?
No, I would argue against that, Your Honor, because there is no legal bright line here about where notice stops and starts. And I think if there was some sort of bright line test where you could apply, you could say, okay, well, this broad notice is getting up to the limit of this test, and we can see that it's still broad, but it's still within the reasonable realm of the notice. But what we're having here is defendants making such broad notice that the public doesn't even understand what's happening, and defendants could go down a slippery slope just by saying, we're going to talk about litigation next. And you know what, we're not going to tell you what litigation that we're talking about, but we're being honest because we're sticking to that topic of litigation. And the public has no idea which litigation they're talking about, if this is a federal lawsuit, if this is a state lawsuit, is this a civil rights lawsuit, is this a lawsuit in equity. They're not giving case numbers, there's no signifiers, there's no identifiers for the public to actually go back and look at this litigation. So it's insufficient for defendants to say, look, we're going to talk about Mr. Cortland, Mr. Hoopy, and Mr. Green, because as defendants even admit, there's a lot of litigation out there. And that's 3 separate men. And in fact, one of those lawsuits involves all 3 men. And as plaintiffs testified, they believe that they were talking about plaintiffs when they mentioned Cortland, Green, and Hoopy, because there were no other identifiers. There was no case number, there weren't any dates associated with it or anything else, so that anybody could identify whether they were talking about the litigation that involved all 3 men or separate litigation that involved specific men. And it turned out that defendants were referring to specific litigation. And that's not for the notice is for the public. And so while plaintiffs do respect that there should be some wiggle room for defendants, and we're not trying to nail them down into something unreasonable, the notice needs to be reasonably calculated in order to inform the public. And so defendants, since they have the duty to give out that notice, and they've stated in their policy that it will be accurate and complete, they need to figure out how they can give that notice that's accurate and complete while still giving them that wiggle room. So let me just go over the 3 types of meetings real quick that we're talking about here. So the first one that I already kind of touched upon was the executive sessions, where they provide notice for executive sessions, but they actually take that final action that we're talking about outside of executive sessions. Like Your Honor stated, they provide the notice, but then they can come out later that meeting or next day or some other time. And all of those meetings are identified pretty clearly in the actions that were taken associated with it. And so this is misleading, this is inaccurate, and I want to first point out is that we were kind of talking past each other with accuracy and completeness, and so plaintiffs took the liberty of providing definitions for this court of the standard English dictionaries because these terms were undefined. And so on page 2 of the SIR reply, we got definitions from a couple standard English dictionaries of what accurate and complete mean. And so the word complete in Merriam-Webster's and dictionary.com basically means having all the necessary parts, elements, or steps. And the word accurate in Merriam-Webster and dictionary.com basically means exact or precise. And so we're going to talk about whether this notice is complete, having all the necessary steps, and whether it's accurate, whether it's precise and exact to what they're trying to convey, because these are their terms. And so first of all, with these executive sessions, these are not complete and these are not accurate. First of all, it's not complete because the case law is clear that executive session notice only covers discussions. And it's not disputed that defendants were coming and taking votes and taking final actions, and that notice doesn't cover that final action. So that's incomplete as a matter of law. It's inaccurate because it's not precise and it's not exact, because an executive session means it's a closed door meeting in private. And defendants were correct that it could cover attorney-client privilege and other sorts of things where conversations with the public is not allowed to be in. So it's giving mixed messages when defendants are saying, we're giving you notice of this final action, but the notice we're giving you is a closed door meeting that you're not allowed to attend. And so that's not exact, that's not precise. And so it doesn't meet either of their standards of being accurate or complete. So the second type of meeting that we'd like to talk about is the November 28th, 2018 meeting. And this is just one meeting that we'll be talking about here. And at this meeting, defendants identify this as a staff meeting, and they talk about they give the notice of Cortland, Green, and Poopy litigation.
Sorry, that date again?
November 28th, 2018 at 10 a.m.
Okay.
I believe that's correct. And so this is not an executive session where they come out and they take a final action. This is something that's identified as open to the public. But again, they're talking about Cortland, Green, and Poopy litigation. But in this specific meeting, the meeting notice, meeting minutes identified that they were just talking about litigation with Mr. Cortland. And I don't think that's in dispute either. And defendants argue that they have a right, as we just went over, defendants argue that they have a right to take action on any of these subjects as long as they gave notice, because this is an open meeting, anyone can show up, and it's a broad notice of Cortland, Green, and Poopy litigation. But this is inaccurate and incomplete. So this is incomplete because it doesn't have all the proper steps, because there's no way that the public could identify what the lawsuit was about. There's not a complete identification of the case title. There's no case number given. If they're going to reference litigation, just like in this court, if defendants were going to come in and say, we're going to talk about Cortland, Green, and Poopy litigation, I don't imagine that this court would know what they're talking about. The public on the other hand, doesn't know what they're talking about either. So it needs to be more precise, or it needs to be complete. It needs to be complete on that matter, and have all the proper cards, so that the public can identify which specific litigation that they're talking about. And even if they, I would even imagine that even if they want to talk, they may want to talk about more than one litigation, and then they don't want to talk about that, then list the possible topics with the possible lawsuits. So we're going to talk about Mr. Cortland versus Lewis County. That case number is blah, blah, blah. And then we may talk about Portland, Green, and Pookie, and that case number is blah, blah, blah. So I think there are procedures of what defendants could do to give themselves that wiggle room, but also adhere to the accurate and complete standards in their 2017 meeting policy. And so it's inaccurate because they didn't talk about Portland, Green, and Pookie litigation. They talked about something else. They talked about Mr. Portland litigation. And there was at the time, Cortland, Green, and Pookie litigation. So that's not exact or precise. And then the third and final type of meeting that I want to talk about is the meeting on March 13th, 2018 at 3:30 p.m. And
I'm sorry, March 13th?
yes, yes ma'am. So March 13th, 2018 at 3:30 p.m. And the notice for that meeting is a payment for judgment at a budget update meeting. And again, I don't think that's in dispute either. And this is inaccurate and incomplete. So first of all, this is incomplete because this was only identified as a payment for judgment and didn't identify a cross appeal. The meeting minutes identified that they paid a supersedis bond in a lawsuit. And second of all, that they voted to, the defendants voted to cross appeal that case. Those are two separate actions. And a payment for judgment doesn't encompass either of those. So it didn't have all the proper steps. It didn't say, we're going to put money into the court registry and we're going to file an appeal or cross appeal. And so it's inaccurate because they didn't pay the judgment. They paid it into the court registry and they may get that money back. So it misleads the public into thinking that the matter is final and that it's settled when it's not settled. It's just continued. And so that is inaccurate and incomplete too. And again, that's fully briefed. So we would urge this court just to apply the plain English definitions to accurate and complete. And for the meetings listed in the response and SIR reply, we do not believe that defendants have met their standard at the 2017 meeting policy. Thank you.
Thank you. Mr. Catlin.
So I'll start with the March 13th, 2018 open meeting. If you look at the minutes, what is discussed, in fact, is an error on the part of Mr. Eisenberg in securing the supersedious bond in a previous meeting at a different amount. What they wanted to do was pay into the court registry the judgment amount that includes interest. And in fact, the minutes also show that they did discuss a budget impact as it relates to that decision. That decision was made in January 29, 2018, and it was made again in March 8, 2018, after Mr. Cortland filed his own appeal. And then Mr. Eisenberg recognized his error and asked for over $60,000 to be paid into the court registry. So I'm not quite sure how this is not an accurate, the payment of judgment is not an accurate impression of what actually happened at the meeting, because they did pay a judgment. It went into the court registry and it's being held there for the purposes of the appeal. A decision that was made in open session after discussion. It should be noted that oftentimes plaintiffs use the term reasonably calculated, but I'm not sure what would be reasonably calculated when the public, if I were to see my name and litigation behind it on an agenda, I would think they're going to be talking about my case or cases. And Mr. Cortland, Mr. Green, Mr. Hubie have together had over a dozen cases going related to the same topics. So I don't quite understand, again, why that is not reasonably calculated to inform the public that the BOCC would be talking about litigation. And then again, the topic itself according to our own meeting policy, it says may. They may take action on any, that they may discuss or take action on any of those matters that are listed on the agenda. They took action on one of those matters.
Mr. Gatton, I have a question. Your time has expired, and I apologize that we don't have more time, but I have a question regarding your motion overall. As Mr. Thomas indicated, we've discussed the nature of these claims before, and your motion appears to ask the court to rule not only on the OPMA alleged violations as a matter of law on summary judgment, but also regarding essentially whether the county has complied with its prior settlement of another case. And I'm not sure how that plays into this case. I've looked at the complaint, and in reviewing your briefing, it doesn't appear that you've addressed that issue as much as you've argued that the OPMA is the standard.
Your Honor, I believe what I stuck to was what the 2017 meeting policy says and how it interplays with the Open Public Meetings Act. The discussion about whether, if it were the case that we did not comply with the meeting policy, it does not entail a violation of the OPMA, stems from what the court did say, where the parties agree that if the BOCC complied with the meeting policy, then there's no violation. I don't think it entails the reverse. And all I wanted to point out was that the case would still be live if it were the case that the court found that we did not comply with that policy, but we're not conceding that.
Thank you. Anything else, Mr. Thomas?
Real quickly, I understand the time constraints. Just that if the court is going to look at the OPMA independent, then defendants, Mr. Gatton is basically telling his clients that he could ignore the agreement. And that would be a slap in the face to plaintiffs. It would waste this court's time, and it would frustrate the public too, because then they're just entering into agreements under false pretenses and backing out of it. And that's, I don't think that's what Mr. Gatton's saying. We need to look at just the 2017 meeting policy. Thanks.
Thank you. The court is prepared to issue a ruling at this time on the motion before it. This motion is brought by Lewis County, and the court understands that there is a motion to strike certain evidence. The court has considered that motion in considering the evidence presented in, actually argument, I should say. The court has considered that argument as to whether the pleadings provided by the county should be considered by the court or not. But I have reviewed them, so I am denying the motion to strike, and I am taking into account the argument with regard to the motion to strike in addressing the pleadings of the county. The court has reviewed the pleadings from both sides with regard to this motion, and I did ask the parties to brief this matter again because I think it's very critical that the court look at each meeting at issue, each agenda, and all of the notice provided. I think Mr. Thomas makes some excellent points with regard to the purpose of the Open Public Meetings Act and the perspective of looking at it from the public, from the public's perspective. However, I also think it is necessary to consider, as the case law does, the practicalities of the situation. And while Mr. Thomas offers some very helpful definitions of different aspects of notice, and I think it's helpful to the court's analysis, the court must rely on the statute and case law interpreting the statute to determine whether these notices were compliant or not. And based upon that case law, the court finds that the notices for each of these meetings was in compliance with the Open Public Meetings Act. and the court is granting the motion of the defendant, the court finds as a matter of law, when construing all of the evidence in the light most favorable to the plaintiff, that there was no violation in these particular notices. Although the court is granting the motion, I will say that I remain unclear as to whether claims remain in this lawsuit. And I come to that conclusion after reviewing the complaint and understanding prior hearings and the briefing on this motion. So I will leave that to another day, but the court at this time is granting the motion. Do the parties require any further clarification?
Yes, Your Honor. Are you rolling under the 2017 meeting policy or just the OPMA?
Just the OPMA. Thank you for that question. And so I will sign an order that is agreed to as to form presented by the parties, or it can be presented at a future hearing. I apologize that we don't have any time today to address the form of any order, but I will address any requests for clarification.
I have none at this time, Your Honor. I believe Mr. Thomas and I can work out an order and present it ex parte as soon as possible.
Thank you very much. We are concluded for today.